The SCRA, that's a federal law, and it is providing protection for service members against default judgments, meaning people can't just go ahead and sue, including sue for divorce, an active military service member when they are. Hello, everyone. Thank you for joining me today. My name is Holly Mullin, and I am the managing partner at Sterling Law Offices. Today, I will be talking to you about something that is unique in a divorce case that can create some pretty significant complexities and can create really long-term problems for clients if it's not done well the first time through. And that is the handling of military issues in divorce. So I had come across my first military divorce really early on in my practice. I was probably only practicing for about 2 or 3 years. And I realized very early on that this was a unique creature, really, handling a military divorce, that there was going to be some nuanced issues and complexities that I had not dealt with before in a more routine civilian type divorce. And I remember having this fear in doing the case because I was so afraid I would miss something. So I promptly signed up for 2 different continued legal education courses to make sure I was covering my bases and that I had my bearings when it came to understanding what to be looking for, what documents I needed to review, what federal laws I needed to understand. Because typically with divorce, we're so very focused on state laws. Federal laws aren't as involved with divorce. I mean, certainly we have some with regard to like dependent exemptions and head of household and other tax issues. But typically we're talking state law when it comes to divorce. So let's talk about the ones that specific financial issues that come up in military divorces, what to look for, and things to know. So, starting with kind of a very basic but important first issue in filing a divorce, which is jurisdiction. Where are you supposed to file a divorce if you have a military spouse who doesn't live in the state, maybe doesn't even live in the country? So, the correct court to file a divorce case is determined based on either where the military member is stationed, if they're stationed in the US, right? The state of their domicile, or the state where the non-military spouse lives. So you have options. Okay, that's a good thing. There's some flexibility there in determining where you can file for a divorce if you yourself are a military personnel or if your spouse is a military member. Okay. One of those acronyms is DFAS, DFAS, and that's the Defense, Finance, and Accounting Service. So DFAS is important because DFAS is going to be playing the administrative role with regard to income statements, so leave and earning statements, the military retirement pay, division of military retirement pay. They house that information and they will be critical in determining whether certain financial aspects can be divided directly and paid out to an ex-spouse. So DFAS is something you may hear in going through a divorce. Another acronym that you're going to probably hear is SCRA. That's the Soldiers and Sailors Civil Relief Act. Try saying that 5 times fast. So the SCRA, that's a federal law, okay, and it is providing protection for service members against default judgments, meaning people can't just go ahead and sue, including sue for divorce, right? That's a lawsuit. You can't just go ahead and sue an active military service member when they are serving our country. And enter a judgment against them without them having the opportunity to participate and defend themselves in the case. So there are certain rules that will come into play through SCRA as it relates to appropriate service, timing and scheduling of court hearings. You may be postponed altogether if they're actively serving. and unavailable. Alternatively, they just may be given, just some offerings to make it easier for them if they're out of state or unavailable for purposes of scheduling hearings, allowing them to appear virtually, and that kind of thing. When we start talking through rights and responsibilities within divorce, again, I'm specifically referring in this episode to financial issues in military divorces. One of the, again, it's another acronym and a rule that comes into play is the Uniformed Services Former Spouses Protection Act. Okay, so this act is very specifically referencing a former spouse, meaning somebody who had been married to a military service member and is no longer married to them. So this is speaking directly to what their rights are in a divorce and what their rights are to certain property income once they are no longer married to the service member. So this is a federal law that goes back 1982, right? So you're talking nearly 50 years back that this law was created to create certainty both for the military service member and for their ex-spouse. So we need to understand, for example, retirement pay. That's a big one. And I've heard a lot of clients, whether it be the soon-to-be ex-spouse or the actual service member client, that says, my military pension is protected. That cannot be divided. And that's not correct. Okay. There are rules around it, but to say that it's a non-marital asset that cannot be divided is inaccurate. A military retired pay is most certainly a marital asset in Wisconsin. Whether it can be divided directly through DFAS, that's the question, because there are rules around how long you have to be married, how long the service member had to be serving during the marriage, but it is in fact a marital asset, the value of which is certainly subject to consideration in the overall property division. Going back to DFAS, they are responsible for managing and processing payments for the military personnel. Okay, so that would include their military retired pay. There's something called the 10-10 rule. Okay, it is going to determine whether a former spouse is eligible to get payments directly from DFAS as it relates to that military retired pay. And when I say 10-10, those numbers relate to number one, the length of the marriage. So the first 10 is, have they been married for at least 10 years? The second 10 relates to years of military service that overlap the marriage. So meaning, were you married for at least 10 years during which there was a service member's creditable military service? So if you have the 10-10, the ex-spouse is eligible to receive payments directly from DFAS if that military retired pay is divided. Okay? So they don't have to wait for their ex-husband or ex-wife, whoever the military service member is, to write them a check for payment. They can get their share of that military retired pay right from the source. Okay. If you don't qualify for the 10-10 rule, let's say you were only married for 8 years, or you were married for 15 years, but the service member was only serving, they only had creditable service for 7 of those years, right? So for whatever reason, you don't meet the 10-10 rule, that doesn't mean you're not eligible for payments out of military retired pay. Okay. You can still receive payments. They just have to come through your ex-spouse or through the military service member, right? So it could still be valued as a marital asset. It was accrued during the marriage, and there is a marital asset to that military pension. And we have to determine then how much of it is marital, how much is each person's award supposed to be. But the payment is going to have to come directly from that military member. When they receive their payment, they'll have to cut a check or send a direct payment to the ex-spouse in order to accomplish that payment. And that happens all the time. That is not that rare. It's just making sure that you have an attorney who can walk you through that and knows how to draft the order. Because if they draft an order, a court order, remember in divorce, a civilian court, that's a circuit court, a state court. DFAS is run by the federal government, and they are not going to care what that state order has to say. They're going to say that's not enforceable with us. So even though you have this divorce decree that says DFAS has to give me 50% of that military retired pay, they're going to say, tough luck, you should have read the rules, because that doesn't apply. You're not eligible to receive it from us. So try again. So making sure that you have that covered is going to be really important. So in addition to military retired pay, right, that's just one of the financial issues that comes up in a military divorce. Another is the benefits, right? So you have, as a military service member, pretty phenomenal benefits, one of which is TRICARE, so health benefits. So again, as it relates to a former spouse of a military service member, they may be eligible to have continued TRICARE health benefits post-divorce. Certainly the children are eligible, but I'm talking specifically about the former spouse. TRICARE benefits, again, I'm talking numbers. So we have a 2020 rule and we have a 2015 rule. Okay. So the difference between those is that if the marriage is 20 years and the service member's service is at least 20 years, okay, so that's the first 2020, because one is 2020, one is 2015. So the 20 and the 20 are the same to begin. Length of marriage is at least 20 years. Service member has at least 20 years in. And then that third 20 for the first option means they overlap. The 20 years of service, the 20 years of marriage, they overlap. The 15 is that only 15 years overlaps. And it's a big difference, and it's an important difference, because in the 2020, that former spouse can keep TRICARE benefits indefinitely, meaning they are covered just as the military service member is covered under TRICARE. Whereas the 2015 provides TRICARE for 1 year. Okay, so that 5-year difference of overlap has a monumental difference on TRICARE benefits post-divorce. So big deal, right? That's really important. And then for purposes of our episode today, the last one I want to talk about is the GI Bill. So specifically the post 9/11 GI Bill. And when I say GI Bill, this is paying for post-secondary education for a service member. And service members can reassign that benefit. So to a dependent and a spouse, they can transfer that benefit. So it's important to know that it is transferable during the marriage. However, it's not considered a marital asset that's divisible at divorce. In other words, a civilian court cannot require the GI Bill to be transferred to the non-service member spouse. It cannot be ordered. Okay, it can be done voluntarily as part of the overall negotiation, but it cannot be forced upon the service member. By mutual agreement, yes. By court order without an agreement, no. But it is something to think about when you are negotiating a divorce, because that's an incredibly valuable resource and benefit available to the service member. If it's not going to be used, it should be talked about and considered what will happen with it. It's a lot to take in. I understand we crammed a lot of good info into a short time frame, but knowing about these issues, even if you can't recall everything I just said, knowing that there are very unique rules and very important long-lasting implications for military divorces, that if you don't know what you're looking for, or if you don't have an attorney to know what to watch out for, you may lose pretty big. So it's good to be prepared and advocated for when it comes to these more complex type cases. Thank you so much for joining me today.
Military divorces come with unique federal rules and strict requirements. But even in a standard divorce, dividing property isn't always as simple as 50-50. Watch this next video where we break down how marital property really works in Wisconsin and why the split often surprises people. Click to find out what's actually fair and what can catch you off guard.